right, not a standalone separate right, but a essential component of the stock water right itself. That's my argument. The claims court had also addressed that in a sense, and talking about on their 1866 right-of-ways that it is necessary for the cattle to forage while putting that water to beneficial use. Now, the only way that we felt that we could use our water rights, since there is no taking of that stock water, is to use it in the historical and customary manner in which it had always been used, and that is by taking cattle to the water, knowing that we were probably taking a chance that the federal government was going to come after us in a trespass action, which they did. They filed a trespass action against me personally and my father. At that point in time, the estate, both my parents, my mother and my father, had passed, and shortly thereafter also my stepmother had passed. I chose to take my case on alone and represent myself, and the estate had to be represented by an attorney, and Mark Pollard represented the estate, so we worked as a team. By doing that, basically it was a simple decision. I could not afford a lawyer. It was cheaper to learn the law than it is to try to hire a lawyer, and that's basically what the decision was. But it gave me quite wonderful insights into the law, and I got to where I enjoyed it. It's a roller coaster ride, I'll tell you that. Some days are great and some days are really bad, but just keep going on. Anyway, the government brought the trespass action against me, and they basically simply said, look, the government owns the grass, okay? They own the forage, and you don't have a permit, so therefore you're obviously a trespasser. I had a defense to that. My defense was, look, I'm making an honest assertion of these stock water rights. When the permit was taken from us, we argued that that was a taking, and the government came back and said, no, that's not a taking because a permit has no effect on the water rights. Well, if it doesn't have any effect on the water rights, then we should be able to use those water rights without the permit. Okay, we were making an honest assertion of that water. It was the only possible way that we knew how to use it. If we tried to take the water off the land, which is one argument that the government made, then we knew full well that the government was going to come after us and do bad things to us. We had tried to clean an 1866 Act ditch before, a ditch which the government had no control over. Yet they prosecuted my father for cleaning that ditch with just simple hand tools. They came and prosecuted him for it. So the only way that I knew to protect the estate's water rights was to put my own cattle out there and take a chance on this trespass. And they did bring it. Well, we got a wonderful decision, actually, out of the trial court originally. In fact, that trial court had said that the government had intentionally entered into a conspiracy to deprive my family of their water rights and range rights. It was a monumental decision. That decision was appealed on up to the Ninth Circuit, and the Ninth Circuit overturned it. And the reason for that was the government had argued that the judge was biased. In fact, one of the comments of the government attorney was, look, we always win. This can't be true. The government must, or the judge must have been biased. And the court ruled that the judge was in fact biased. I don't believe he was. And if he had been in that trial, I don't think you would think he was biased either. The government attorneys conducted themselves in a very poor manner. And the government people had conducted themselves in a very poor manner. So the Ninth Circuit ruling, now this one's really quite interesting because this is a ruling that everybody looked at like this is a humongous loss. Actually, it's not. It's not a loss at all, and here's why. They ruled that I have to have a permit in order to use that grass, use the forage. Because we all know that cows eat grass if they're going to go to a water source. However, knowing that they cannot deny access to that water because access is an essential component of any property right, their solution was the same solution that they gave the Hunter family back in the 1960s in Death Valley. They said, you have the right to remove that water off the land. And you have that right through the 1866 Act. And that right-of-way already exists. Okay? We can remove that water at any time. Well, now, we look at that and you think, that just doesn't make any sense at all. You know, that water and that forage is connected. That's my argument. And to sort of remove all the water off the land doesn't seem like a very reasonable solution to the problem. The case was remanded to the trial court to find out how much money I owe the government and whether the trespass should be, whether the damages should be governed under state law or federal law. Upon remand, I got Judge Navarro down in district court, and basically they used about the highest cattle number that they could conceivably figure and put the highest rate on that and put a judgment against me personally for $580,000. I had no choice but to appeal, and I did. And just last week we had a hearing on it. That hearing was quite interesting, to say the least. The question that the court had was a willful trespasser? In other words, was willfulness a part of it? Because that goes a lot to the amount of damages. If I had a good faith belief that what I was doing was right, even though if I was wrong under the law, if I had a good faith belief that I was right, then that weighs heavy on whether it's willful or not. So upon answering the question, I brought up the fact that the United States, that the judge had ordered me in the first trial court to go get a permit, and so I applied for it. The judge had also ordered the government to grant it, which they did not. After remand in front of the lower court, that judgment was vacated, and the government asked the judge if they had to give me a permit now, and that judge said no. No, the court said no. That has been vacated. And they smiled and promptly canceled my application for a grazing permit. So I did what the court asked. I applied for that grazing permit so that I could access those water rights by taking the cow to the water. They denied it. So then I went into I asked the government, I asked them 3 times, I'm going to take that water off the land. Are you going to do any bad things to me? We've obviously been in court for a very long period of time now. Let's save ourselves some trouble. If you're going to try to throw me in jail or prosecute me or whatever, let's just get it out in the open now, and instead of me trying to dig the ditch and then find out that you're going to come arrest me. The government all 3 times said, no, we will not let you take that water off the land. And I said, wait a minute. The Ninth Circuit has just ruled that I can take that water off the land under the 1866 law, and the government still said, no, we absolutely will not let you do that. Except in maybe 2 or 3 little water rights out of our 130, if we take them a very short distance, they might think about it. But the rest of them, no. But they can't either. Because those water rights, a lot of them are in the wilderness areas. And if I take equipment up there, like I'm allowed to do under that 1866 law, and take that water out of there, then that'll drain the water off the land. A scenario that they don't want. So they denied me 3 times. In this hearing, when that was brought before the Ninth Circuit, those judges were absolutely amazed. They could not believe that. In fact, the one judge, he said, wait a minute. We are the judge, not the federal government. I said, well, that might be so, but when I go back home to Tonopah, it doesn't work that way. Those guys are acting like the judge. And I'll tell you what, they got quite pointed with the federal government attorney. In fact, I even asked the federal government attorney, are you going to allow him to take that water off the land? She would not answer the question. She said, well, it's more complicated than that. He said, what's more complicated? They own that right to take that water off the land. You know the argument that the United States government made? Said, but Your Honor, the forage and the water is so intimately connected that if the Hages take that water off the land, we won't be able to manage it how we want to. She made my argument for me right there. Yeah, that's correct. And the court also recognized that this is ripe for an injunction, for me to get an injunction against the federal government to tell them stop. We have that right to take that water off the land. Where do you take it? We know point A of where the right-of-way starts. Where's point B? Interesting question. What happens if a person buys a piece of property in a city, Las Vegas, for example? Does that water extend down there? Does that right-of-way extend down there? When you think of 130 different right-of-ways to drain that land of that water, it puts the rancher back in the driver's seat, because that is the solution that the government does not want. And that's why this is a victory. Because in order for them to solve the problem, they're going to have to make our argument for us. They're going to have to argue that that forage and that water are intimately connected. They're going to have to start granting permits, or ranchers are just going to say, look, I'm going to take my chips and go home. If we shut off our wells, just our wells alone on the winter range of the ranch, we shut down 600 square miles of water in central Nevada. I know that sounds like a lot, but take a look at the map. It's a large portion. We own all the water out there. Similarly, the Hunter family still owns all the water in Death Valley. According to the Ninth Circuit, all 26 sources and the entire flow of all 26 sources, and the Hunters still have the right to remove all the water from the driest place in the North American continent and take it somewhere else. That's the solution that the government wanted. That's the solution that they argued for. They got it, now they don't like it. Pretty interesting, isn't it? Well, not only that, but it revives, and this is the interesting thing. By the government denying us the ability to exercise our 1866 right to take that water off the land, and by denying us a permit to access the water that way, they have just completed the taking for us on the stock water. At the same time, I asked them if I could clean the irrigation ditches, the 1866 Act ditches that the claims court had previously found that we owned. You know what the Forest Service response was? In a nice letter, they said, we, the Forest Service, are not allowed to determine whether that's an 1866 Act ditch. Only a court can. And we don't recognize a claims court case because that's been overturned. I guess they must think the claims court's going to come to a different conclusion with the same evidence next time? I doubt it. They said, we don't recognize your 1866 Act right-of-ways except for maybe one. And if you want to clean it, you better come to us first. Otherwise, we might prosecute you. They just completed a second taking on our irrigation rights. That case is ripe now, too. So now what's the government faced with? A taking on the stock water right, a taking on the irrigation water right, and now an injunction. We're in good shape now. The judges were so amazed. They said, you know what, this case has gone on for so long that we probably need to throw this into mitigation, because in mitigation we can settle all current, pending, and future lawsuits. And even talking about mitigators and how the court had very excellent mitigators free of charge, the one judge said to the other, said, we might want to get a judge involved in this one because we might need a little bit more horsepower. The court sees the problem here. The government got the solution they wanted, now they don't like it. And it was very telling about how the U.S. attorney It was quite telling when the U.S. Attorney had answered that question that they don't want that water taken off the land. And this goes back to the conspiracy that the previous court had found. The previous court had found that no matter what we did, the government was going to try to prevent us from using our water. And that DOJ attorney had basically said, look, we can't allow Hage to take the water off the land, because if the Hage family takes that water off the land, we can't manage it how we want to. We don't want to give them a grazing permit, and we don't want to let them take the water off the land. So that completes this conspiracy. What Judge Jones found is in the conspiracy was correct, and she admitted to it right there. So anyway, it's quite amazing. So where are we now? Tell you the truth, I don't know. I mean, I guess what I'm trying to tell you is don't give up. Don't give up. When we thought everything was lost, now all of a sudden everything got turned around. Both takings are still back on the table now. The government has a very serious problem. And think of the implications of this decision. For example, if you have a vested water right, and that water right is good for, say, like 100 head of cattle, to give an example, and if they try to give you a permit but limit you to 50 head of cattle on that particular water right, and even if the water right's good for a year, they say, okay, well, you can only use that portion of the range for half a year, 6 months, well, then they're denying you access for the remaining part of the cattle and the remaining part of the year that that water right is good for. You can take that water off the land now, can't you? Think about it. You have a lot of power over the United States permit system, the grazing permit system. An amazing amount of power. When you follow the whole thing through, the stock water right holder now, I think, is in the most powerful position. And the government is in big trouble, very big trouble. But you have to be willing to take that water off the land. And it's not hard. Might not say it's easy, but it's not hard. I'm working on a ranch right now where they've got 130 miles of pipe coming out of one spring, watering that ranch. It's doable. I've seen it. It's really quite doable. And remember the main thing, the government doesn't want that water to be removed. So if it doesn't get removed, they're going to have to pay for it. Now, another interesting question. If the government prevents you from taking the water off the land, and they also prevent you from accessing it with cattle through the permit, there's a taking there. Is that taking temporary, or is it permanent? Well, what if you get to qualify for a permit the next year? I think it's a temporary taking myself. It could possibly be a permanent taking. But in other words, they might have to pay you the rental value of your water rights for the time that they won't allow you to access it, instead of you losing your water rights altogether. It's a very interesting question. I don't know the answer. I suspect we'll find out the answer with further litigation. So it's changed everything around for our family. Only 2 weeks ago, we thought this was a big loss. I've been packing my bags. I'm selling my cattle. Now I don't know what to do. There's a possibility that we could salvage this fight and salvage the ranch. Most certainly, the government has a huge problem to deal with. So anyway, thank you for the opportunity to address you, and thank you for the opportunity to give you some good news for once.